Appeals 21 and 22. Matter of National Energy Marketers Association versus the New York State Public Service Commission, and matter of Retail Energy Supply Association versus the Public Service Commission. Counsel.
Good afternoon, Your Honors. May it please the Court, Jason Sorolnik on behalf of the NEM appellants. My colleague and I are collectively would request 4 minutes rebuttal time, and we'll split that evenly.
Very well.
Thank you, Your Honor. This appeal asks whether the legislature imparted to the Public Service Commission the authority to set the rates that private energy service companies charge their customers.
Counsel, if the Public Service Commission does not have broad authority to regulate access to utility infrastructure, how is it that the Commission unilaterally opened the retail energy market in the first place by ordering the infrastructure open to the ESCOs?
So, Your Honor, I think the opening of the market is different from the closing of the market. I think the legislature imparted to the Public Service Commission many areas in which it can oversee the market. In particular areas, including the one that we're focused on today, Your Honor, rate making, the legislature made clear what its intent was with respect to which entities the PSC could regulate rates and which entities it couldn't.
About generally regulating conditions under which their access to the infrastructure can either be obtained or maintained.
So I think, Your Honor, I think it depends on what they're doing. I think if what the PSC is doing is really an end run around the legislative decision to limit rate making to utilities, which couldn't be clearer from the text of the Article 4 that deals with rate making, couldn't be clearer from the legislature's subsequent amendments to other articles, et cetera. I think if that's what the PSC is trying to do and use a backdoor of...
I thought what they were trying to do is just set a cap.
Well,
and doesn't that go to what's just and reasonable?
Well, I think that setting a cap is a manifestation of regulating rates. I think Your Honor is right that the way they tried they tried to regulate rates here was to say the rates can't exceed the rates that are charged by utilities.
Isn't that the legislative intent?
I don't think so, Your Honor. I think the legislative intent is in Article 4, and these words are ellipses out of every single quote that you see in Respondent's brief with respect to Article 4. The words that are excised out or ellipses out are rates charged by electric and gas corporations. And those words are in...
The point of competition is to provide something beneficial to the public. And their position is you're not providing anything, or the ESCOs are not providing benefit to the public because, first of all, they're not charging less. And second of all, to the extent they are charging more, they're not providing some value for the premium.
Your Honor, we agree that's the position they've taken. We don't think the record supports it, although I don't think
Let's say it did. Let's say it did.
Right.
Why wouldn't they be able to regulate in furtherance of the legislative goal, which is to achieve a benefit for the consumer through the competitive market?
I think, Your Honor, two things. Number one, eliminating the competitive market, which is what the PSC would do, can possibly improve things for consumers. That is to restore us to a state of monopoly.
They didn't eliminate it. They just said it's actually got to provide a benefit. And so they've defined a range of benefit,
well,
including
but the benefit,
cost as well as service.
Right. What the PSC tried to do here is say, if you are not providing the benefit, ESCOs can't exist, and if we determine that's the case, we're going to be restored to a state of monopoly. So,
Counsel, I have a more basic question on that. Clearly, there is some authority with PSC to regulate you, and maybe they don't have other authority. Maybe they don't have certain rate making under a different article. My problem with this case is, what are we applying that to? Your regulation isn't here, right? The regulation was thrown out by the Supreme Court here. It hasn't been repromulgated. So we're giving kind of an advisory opinion on what authorities that the PSC may or may not have over you without a concrete example of what they've tried to exercise before us.
So, Your Honor, I think this is, it's more specific than that. I think we had requested below a declaration that the Public Service Commission does not have the authority to set the rates that ESCOs charge, whether it's by a cap, by anything. And
maybe they do, maybe they don't have rate-making authority, but how they promulgate a regulation that may have some effect on your rates is really the controversy. So maybe we could say, sure, you know, they don't. But that doesn't answer the question of whether this particular regulation is good or not good, because maybe, as I think Judge Rivera's questions may have been getting at, this isn't a rate-making regulation. So what are we supposed to decide? In a vacuum, they do, they don't have rate-making authority over you? They do, they don't have Article 4 authority over you? We don't generally do that.
Your Honor, where the relief requested below was for precisely that declaration, I think that it is fair material for the appellate court to review and for the Court of Appeals to review. I think Your Honor is right that the devil is going to be in the details once this court answers that question. And
so if we affirm the appellate division's finding that whatever that particular provision was in Article 4 didn't apply, and they didn't have authority under that provision, that would be it. That's basically what we could do here, or not, or reverse that. That's what you're asking us to do?
I think that's the controversy before this court. I think once this court gives the guidance and particularly considers the issue we raised, whether or not the lower court erred in finding that the Public Service Commission does have jurisdiction to set rates, I think that
they didn't really find that. They found a particular provision of this scheme didn't apply because of the definitional section. But that isn't the end of whether what they do is good or not good. So I don't see how we can reach the ultimate issue of what they did, which isn't before us, whether that falls within a certain rate-making authority or not, because that isn't even here.
Yeah, we respectfully submit, Your Honor, that is the discrete issue before the court. That is, the lower court found that there is rate-making, that there is the ability, the PSC has the ability to set or control the rates that ESCO's charge. We think that the plain language of the statute and the legislative history made clear that can't be true. And Your Honor's right. I think there will be subsequent actions on the part of the PSC that will comply with whatever this court pronounces, and we can see whether or not there's a problem that raises. But there is a discrete issue before the court, and we think that it needs to be addressed, and we think it's fundamental.
Chief, I have one question, if I
Yes,
might.
of course.
I don't understand, counsel, maybe you can clarify your position for me. Is it your position that the PSC does not have the authority right now to say, forget the ESCO market, we're shutting everybody out, utilities no longer have an obligation? Is that your position, or is it your position they don't have the power to set rates?
It's the latter, Your Honor. It's that
They could shut the whole thing down, is your view.
that's not our view, but that's not the issue. That's not the issue before the court.
I'm asking.
You're asking just our
about
view.
Your view about the power of the commission. Does the commission have the power, let's say after after going through SAPA, to say this whole thing isn't working out, utilities no longer have an obligation? Do they have that power?
I think that would be problematic under Boreali. I think that would be a policy-making decision on which the legislature has repeatedly made pronouncements regarding the ESCOs, and if that decision was going to be made, it would need to be made at the legislative level. That is a major policy decision that satisfies all four of the Boreali factors.
Thank you, Counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, David Birch, Barclay Damon, on behalf of Retail Energy Supply Association. I'd like to pick up with a question that was asked previously. Are we aggrieved, essentially, was Judge Garcia's question. If you look at Judge Wack's decision and then the Appellate Division's decision, they find jurisdiction and they remit this to the PSC for further proceedings in accordance therewith. We've now been faced with, nearly 2 years of...
But we don't have that regulation in front of us, right? It's not in effect. And what I find, the Appellate Division, after going through Article 4, says, we find that PSC's broad statutory jurisdiction and authority over the sale of gas and electricity authorized it to impose the limitations set forth in the reset order. That's their holding. We don't have the reset order. So I don't know how we reach that. I think maybe we could reach whether or not that provision in Article 4 covers you or not, and agree or disagree with the Appellate Division on that. But I don't know how then we go on to say whether or not authority authorizes the PSC to promulgate an order that isn't in effect and isn't before us.
I think the question before Your Honors, respectfully, is, what is the scope of that authority? And I think that if you look to Judge Wack and the Appellate Divisions, they find this broad jurisdictional authority over rates, and then the PSC is proceeding in accordance with that. And
What
so
they found in the Assn that I just read is that they had authority to promulgate this order, not a broad authority to do various, things that we could hypotheticals we could give. They found broad authority to do what they did with the reset order. But what would we say? You do or you don't have broad authority to do what? There is no
To do what
order.
they did in the reset order, and that's what I think Judge Wack remanded and had said. You have to follow proper notice proceedings under SAPA, and that's what,
The order is no longer in effect, and
That's-
it's not been repromulgated. Right?
I understand, Your Honor, and we think that the court should weigh in and either uphold or, in our view, reverse the lower court's decision.
But you're sort of assuming a result after the SAPA process, right? I mean, it's possible that the PSC does nothing.
Well, I don't think we're assuming it. The Public Service Commission in that proceeding, and I believe in the briefs, there's some citations to their arguments where they assert they have this jurisdiction. So that's sort of a fundamental premise of what's going on in front of the PSC today.
But I think there have been some new orders promulgated, if I'm not correct, which may be going through various stages, and I'm not commenting on them, but they seem to have been phrased differently than this order.
Well, I think the orders, in kind of colloquially are the low-income orders. That's a separate
Right.
track. That's a separate proceeding. In fact, RISA is not, a party to that litigation. If I might
To
turn.
move to the merits?
That's it. I'd like to turn to, the question of, what did the legislature intend here to be the scope? I mean, we have a good legislative record that goes through decades. We have the legislature opening up the markets to some degree. We have orders from the Public Service Commission implementing
Don't you
that.
also have a history over decades of the PSC establishing various requirements of the ESCOs through the UBPs?
Yes,
Okay,
Your
and
Honor.
where does the authority for that come from?
Well, I think the UBPs are, not before the court,
Well,
whether
I know,
they're
but we're
valid or
looking-
not, but.
But you're asking us to look at what the
What the scope
PSC's
is.
authority is. So I'm trying to ascertain, what we know, well, at least your colleague says that, that they have the authority to require the utilities to allow access to the infrastructure, and then the argument is that, but they don't have the authority to take it away. But apparently, they have authority, because you haven't questioned it or challenged it, to impose various restrictions and requirements and so on through the UBPs. And my question to you is, where do you think that authority comes from?
And so that authority comes from the ability of the Public Service Commission to regulate things within its purview that are consistent with what the legislature has said. So the legislature has said HEFPA applies. Article 2 applies to ESCOs. UBPs can be consistent with that.
But the UBPs came before HEPA, before Article 2, right? So that's,
In-
so.
And at that time, in 1999, I think, when the UBPs were issued, and then 2002, we have the HEFPA shortly thereafter, after there was some dispute over whether it applied or not. Legislature spoke, but the UBPs also, to the extent they're consistent with general, consumer protection things, that's fine. But here you have the legislature saying rate-setting jurisdiction is a very specific
But
thing.
they didn't have the right, I think you say, they didn't have the right to regulate consumer protection things until the amendment to Article 2. My point again is that the UBPs were there before that amendment to Article 2.
And they were, and I was not involved in any decisions on challenging it or not, and I don't know that RISA was. But, the point is here, we have them trying to impose a regulation on rates, which is something the legislature specifically applied to utilities for good reason, because they're monopolies.
Does your argument boil down to PSC can regulate you as much as they want, but they can't touch what you want to charge?
But they can't touch things that the legislature spoke on.
What else is there other than the rates?
I could come up with hypothetical things. Right now, we're talking about rates. Conceivably, if they wanted to shut down the market, I would agree with my colleague, that would be a bridge too far.
Why is that? Doesn't the statute just say may as opposed to must open up that infrastructure?
Well, I think they did open it up, and now we've had decades of people using it. And I see I'm out of time, but if it's okay, Chief, I'd like to finish.
Of course,
yes. They opened the market up. People have been acting in accordance. People have made business decisions, invested a lot of money in New York, and New York, boils down to, and this court's long recognized, competition is a fundamental principle of the policy of the state of New York, and that starts in 1968 in this court's decision, AMC versus Tomar Products, 21 New York 2nd, 621, when a market's opened up, there's competition, it should be allowed to continue and prosper. And the legislature can certainly speak to what the boundaries of rates are, but here they did, and they applied it to public utilities, gas and electric corporations, which ESCOs are not. The third department got that right. Thank you, Your Honors.
Thank you. Counsel?
Good afternoon, Your Honors. May it please the Court. Scott Bassenson on behalf of the New York State Public Service Commission. Your Honors, the Commission's order here implemented a legislative policy that's over a century old to protect consumers who purchase essential gas and electric service, utility service, by ensuring that such utility service, including its price, is just and reasonable. The legislature's policy and the Commission's jurisdiction over the sale of that essential energy applies irrespective of who is selling the energy. The Commission's authority is broad and specific and clearly set forth in the plain statutory language of the Public Service Law and more recently the General Business Law, legislative history, and over 100 years of regulation and case law. In addition, this court, over 65 years ago in Campo v. Feinberg, affirmed the Commission's broad jurisdiction over the utility distribution system in upholding a Commission determination to eliminate third-party resellers. In that case, they were known as submeterers. How that worked was the submeterers or landlords would purchase the energy from the utility and resell it to tenants. So they were a third-party energy reseller, such as ESCOs are here.
So who's being regulated? Are the ESCOs being regulated, or are the utilities being regulated into whom they may or must open their infrastructure?
Yes, the Commission regulates the utilities directly and over there, under sections 5 and 4 and 65 and 66. Direct regulation of the utilities and their infrastructure, and the Commission in 1996 determined to open the market to allow ESCOs access to that utility distribution system. And so, as in Campo, the Commission's jurisdictional authority over the utility distribution system is broad enough to encompass regulating the price that ESCOs can charge for the commodity, which is the same thing that the submeters were selling.
Well, does it make a difference to your authority if the rule is phrased, say, option 1, ESCOs can't charge more than X, or it's phrased, utilities do not have to allow an ESCO access unless the utility is charging not more than X? Does that make a difference to your authority, the way that's phrased?
No, Your Honor, because both of those things derive from the Commission's statutory authority and duty to ensure that the essential energy services, utility service.
Right, but one is, just to be clear, one is a regulation of the utility and the other is a regulation of the ESCO.
Yes, Your Honor, and they both derive from the same duty to ensure safe and adequate service at just and reasonable rates.
So could you require that their rates be 20% less than a utility?
That's not the issue before the court, Your Honor.
I'm just trying to get a sense of the scope of the authority that you're arguing for on behalf of the PSC. I understand that we're talking about a cap, and I get that, but my question is about the scope.
If it were determined that such a rate were just and reasonable under the PSL, that's possible. But this particular case, it was determined because the utility price for the commodity is by definition just and reasonable under the Public Service Law, that in order for ESCOs to continue to serve the market, they had to meet or beat that utility price.
So let me ask you this. So that's in furtherance of competition that benefits the consumer, correct?
That's correct, Your Honor.
So if it's exactly the same, what's the benefit to the consumer? The exact same fee, where's the benefit?
For the commodity itself, it would be the same price. So,
What's the benefit to the consumer?
well, if the ESCOs, and again, the Commission's not it's not the Commission's duty to ensure that ESCOs make a profit. But if ESCOs find a way to either hedge in the wholesale market or offer value-added energy services that would benefit the consumers. If they could purchase the energy for below the
So they might
cost.
still give more at the same price, is what you're saying?
That's correct, Your Honor. That's correct.
But if they didn't, if it's exactly the same, how does that help the consumer? I can choose from the same 4 companies that give me exactly the same thing, or 100 companies.
Essentially, the energy is passed through and they get the service at the same price.
So that sounds to me like an argument for competition for the sake of competition, or the existence of just more choices that are meaningless at the end of the day.
Well, it may be that the commission would consider that in determining whether the market should continue. If there is no, the whole purpose of the market was to benefit consumers. In fact, goal number 1 was to lower the price for consumers. And that figured heavily in the commission's determination here that in order to make sure that the price is reasonable for consumers, you either meet or beat the utility price.
So one of the provisions is that they can charge more if they provide some alternative energy options.
That's correct. There was one exception in this order which allowed ESCOs theoretically to charge more if they committed to using 30% renewable energy. And there's statutory authority for the commission to order that under Section 5, Sub 2. It requires the commission to encourage programs for environmental issues and
Are there other value-added things other than that you can give me examples of that might
I would have to
provide
say the commission's been hard-pressed to find them, and that is why, over the years since the market was open, the commission has initiated several proceedings in order to determine if the ESCOs are bringing any value-added services. What was found was that the price was higher than what utilities charge, but it was difficult to identify what, other than costing more for the commodity, what the ESCOs were actually providing.
Do you have a view on the aggrievement or mootness, ripeness issue?
Well, we did raise the agreement issue in this court. We believe that the appellants received the relief that they requested. They filed an Article 78, and they sought invalidation of the 3 ordering clauses, and that's what they got.
But they didn't get the declaration they wanted, did they?
Well, Your Honor, the declaration, they haven't preserved that issue before this court. They didn't raise it in either brief before the appellate division, and they didn't raise it in this court until their reply, and we haven't had an opportunity. So we would argue that they just never preserved that issue.
Oh, if we were to find, you also order mootness. If we were to find that it was moot, then it was moot before the appellate division, right? So wouldn't we have to vacate the entire appellate division order, including that part that essentially, I think, says that you have the authority to issue the reset order?
I have 2 responses, Your Honor. First of all, no one has requested, the other side has not requested that you invalidate the appellate division order. But I would also point out...
But we might have to do that if we found that it was moot, wouldn't we? Well, let's just say we would. Then the effect would be theoretically to throw it out, right?
If you were to invalidate the order, it would no longer be in effect. But as far as the jurisdictional issue, I would point out this, I forgot which of you mentioned the low-income order, but there is a live order of the appellate division, 3rd Department, relating to a similar order issued by the commission directing ESCOs to meet or beat utility prices with respect to low-income customers. And that order was upheld by the appellate division, including the issue of jurisdiction under a full Boreali analysis as well. So even if you were to...
But aren't you in part able to move forward with that because of the decision by the appellate division in this case? Because they had not decided in favor of NEM and RESA that indeed the PSC had the wouldn't that litigation have been dead in the water? You couldn't move forward with that, could you? Couldn't move forward with that order.
In the low-income order?
Correct.
That's correct. But that order was issued after the appellate division order here. And
But that's my point. There are consequences flowing from that order that affect them. That's my point.
that's correct. So even if this court were to invalidate the appellate division order on agreement grounds or mootness grounds, the low-income order would still be in effect and would be settled law And I do note that the appellants, one of them is NEM appellants, have chosen not to seek leave to appeal that decision to this court.
But let's say in the Supreme Court, they win, as you say, that it gets tossed. The rest of the Supreme Court order is out there. You repromulgate. You comply with SAPMA. They challenge again. Wouldn't you come in and say that you can't do that? You already got a decision. So didn't they, in effect, have to appeal?
They would have to appeal the Supreme Court order?
But could they do that then? If they didn't appeal, if what happened here and they didn't appeal, and then you repromulgate and you comply with SAPA, then they come in to challenge, wouldn't you say it's too late? You didn't appeal the other order? The Supreme Court order stands?
We would certainly argue that the low-income appellate division order...
Not the low income, this case. So if they hadn't appealed and said, look, we won, let's go home, we won on SAPA grounds, and you went out and you repromulgated in compliance with SAPA, and now they want to challenge, would they have a problem because they didn't appeal the original Supreme Court order?
No, Your Honor, because they weren't aggrieved by the original Supreme Court order. They won what they sought. They sought invalidation of the order. If the commission, after its ongoing proceeding, issues another order, they'll have an opportunity to challenge that if they're unhappy with it, and they can raise whatever issues they want to the Supreme Court. Your Honors, I could address the Boreali issues if you would
Please.
like that. So the first part of the analysis is what's the function of the agency? So in order to do that, let's look at, I sort of conflate that with the first element of the four-part test. So let's look at the legislative declaration of policy, all right? So because Boreali involves whether the agency is implementing a clear legislative policy. So I would draw the court's attention to Public Service Law Section 30, which is entitled Residential Gas, Electric, Steam Service Policy. And it's the declaration of policy by the legislature that the continued provision of electric and gas service to residential customers is necessary to preserve the health and general welfare and is in the public interest. So it's an essential service according to the legislature. That's the declaration of policy. We then go to the broad statutory grant of authority to the commission, and we start with Public Service Law Section 5, Sub 1. Section 5 is entitled Jurisdiction, Powers, and Duties of the Public Service Commission. 5, Sub 1, Sub B states that the commission has jurisdiction, powers, and duties over the entire range of the generation and provision of energy, the manufacture, conveyance, transportation, sale, or distribution of gas and electricity. I draw the court's particular attention to the word sale. This first clause in 5.1b demonstrates the legislature's specific grant of authority to the commission to supervise, and it has jurisdiction and duties with respect to the sale of the energy. The second clause in 5.1b, after
Regardless of the seller. Regardless of the seller. Any seller.
Correct. That's correct, Your Honor. It's over the commodity itself. It's over the whole process. Manufacture.
The market.
Correct. Correct, Your Honor. Then you go to PSL Section 4, Sub 1, which is one of those kind of generic grants of broad authority in which the commission, the Public Service Commission, has all the powers specified in the PSL and also all powers necessary or proper to enable it to carry out the purposes of the public service law. So we have the legislative policy, we have the general broad statutory grant of authority to the commission, and then we get to Article 4 of the PSL, which has more specifics with respect to the commission's jurisdiction over the utility distribution system.
Can I back you up to 5.1b for a moment?
Sure.
Because I think the string you read, manufacture, conveying, transportation, sale, distribution, it finishes with to gas or electric plants. Right, so is it really the whole market, or is it the sale, transportation, distribution, et cetera, to the gas and electric plants?
Gas or electric, I would say that the comma means that the jurisdiction, it offsets the prior clause. So the jurisdiction, powers, and duties apply to those things and also to gas plants, electric plants, and the persons or entities who own or operate them. That's how I would read the provision. So in Public Service Law Section 65, Sub 1, that requires that gas corporations and electric corporations provide service That is safe and adequate and just and reasonable. That's the primary charge of the legislature to the commission, to ensure that these essential energy services are provided in a way that are safe and adequate and just and reasonable. Under 66, the commission can determine whether rates that are charged by these corporations are reasonable or unreasonable and can set reasonable rates. So that's the more specific grant authorizing the commission to regulate the utility distribution system. I see that I'm out of time. A few moments in closing. Closing, Your Honors, the regulation of ESCO sales is fundamentally the regulation of utility service and is designed to protect consumers. That's the legislature's policy, and the commission has merely implemented that policy. If the court finds that the appellants are aggrieved and decides to address the substance of the issues here, we ask that the court affirm the lower court's clear holdings that the commission has the authority to protect consumers by regulating ESCO's access to utility distribution systems and preclude the utilities from carrying overpriced energy.
Thank you,
Thank you
Counsel.
very much, Your Honor.
You're welcome. Thank you. Counsel?
Thank you, Your Honor. And my colleague, Mr. Birch, will have just a couple of points at the end. I'll try to address as many as I can in the short time that I have. Your Honors, I think that Judge Wilson's question hit the nail on the head. This is the answer to the question that you asked in their brief. At page 56 of their brief, Mr. Bassenson answers the question. The Commission does not need the power over ESCOs as corporate entities in order to impose a price cap on ESCOs. That's their position. Their position is that they can backdoor in regulation of ESCO prices without regulating ESCOs. And that is antithetical to the basic tenets of statutory interpretation that this Court has consistently pronounced. Make no mistake about it, this is not an issue where we are operating in a void or a vacuum. The legislature spoke to this issue in 2002. The legislature debunked everything that you just heard in the last 2 or 3 minutes with respect to the meaning of Article 1. If electric and gas corporations and Article 1 generally gave the PSC jurisdiction to do whatever it wanted to in this market and this space, the legislature wouldn't have needed to debate and enact legislation in 2002 to change the definition of the entities over whom the PSC had jurisdiction with respect to Article 2.
Is there a difference between what the PSC does under Article 4 with respect to the utilities and how it sets the rates? Are the rates that it sets under Article 4 a maximum and a minimum, as opposed to what the effect of what it did here is to impose just a maximum?
I think it sets, by setting it's not really a maximum or a minimum, it sets the rates. It reviews the rates that the utility has through a whole process which includes the utilities needing to make a profit. What they've done over here is they said an ESCO cannot operate unless they're charging those rates. And this is an important factual point for Your Honor's benefit. ESCOs often, it speaks to several questions in terms of what benefits are provided. ESCOs offer a variety of products, including fixed-rate products. So that means an ESCO, if I enter into a contract with an ESCO, I am given the opportunity to pay a fixed rate for the next year, 2 years, 3 years, just like a mortgage. Under the PSC's order, if that rate ends up going down, if the regular variable rate goes down, I am being overcharged because I committed to paying 12 cents a kilowatt hour instead of what ended up being 10. But of course there's a benefit to the consumer because they chose voluntarily because they wanted the fixed rate, just like I chose a 30-year mortgage. One of my friends chose an APR that had a variable rate mortgage. Under this rate-setting regulation, they can essentially say every ESCO here is overcharging simply because a customer elected to enter into a fixed-rate agreement. That's not fair. That's not what the legislature had in mind, and the legislature made this clear in enacting its amendments. Rate setting is a separate power.
Well, wouldn't that be an argument then that what it's doing isn't fair and reasonable? Isn't that a different argument?
Your Honor, I think it's also unfair and unreasonable, and I think that is a separate argument. But I think there's a threshold problem here, and they don't get past go if they don't have the authority to set ESCO rates, nor do they need the authority to set ESCO rates. ESCOs are a voluntary slice of the market. Any consumer who doesn't want to buy from an ESCO doesn't have to buy from an ESCO. Any consumer who doesn't want a fixed-rate product need not have it. You don't need rate-setting regulatory authority.
But the legislature's made clear that the point of opening the market is to benefit a consumer. And you don't need 300 choices that are giving you the same choice. Right?
Your Honor,
Which is I understand you may have a different position, but they're arguing that unless the price you charge is exactly the same because you're not doing anything more than the utility is doing, or you're actually offering something for the premium, that's not just and reasonable.
Yeah,
It
but
doesn't meet what the legislature intended.
So two quick points, Your Honor, to respond. Number one, the legislature never even uttered the words just and reasonable with respect to prices the consumers pay. It's about what utilities, at the time that it was enacted, monopoly utilities charge. And the reason was clear. If the utilities can charge whatever they want to in a monopoly, and we all need electric and we all need gas, we have no choice but to be at their mercy. So the legislature, they ellipses out the 39, I think it is, times that Article 4 refers to gas and electric corporations only, and then the legislature spoke to this issue in 2002 and said, we are only changing those references to gas and electric corporations for purposes of Article 2.
So
Only-
let's assume for a moment that the PSC can't set ESCO rates. Assume that. Why can't the PSC say to traditional utilities, you don't have to make your lines and pipes available unless an ESCO is charging less than your rate?
So I don't want to evade the question. I just want to point out that's not the,
I know.
to Your Honor's
I understand
point, that's not the
what
point.
they said.
I think that would be an end run around the legislative intent. I think that the PSC.
But doesn't the statute authorize that?
I don't think so. There's not a single citation to a statute that says that the PSC gets to decide whether or not a particular ESCO or a group of ESCOs or ESCOs generally get to use those lines. That was enacted, and to the question that were asked earlier, it may have been enacted in 99, some of those protections, but most of those protections are coterminous with the things the legislator spoke to in Article 2, and if they weren't, they very well might not have been proper, but it wasn't raised, because shortly thereafter, the legislature spoke and said, here's what we are going to allow you to do. So to Your Honor's question directly, I think it would be wrong to allow the PSC to essentially open up a back door, and back door is the wrong word. It's basically a gaping hole that upends the entire.
But isn't the reality that if you look at the legislative history, you look at the legislative trends, it's to let's deal with the monopoly, competition we believe is a good thing, let's allow the opportunity for that, and then as moving forward, it's the legislature trying to ensure that there's actually a benefit and that there are protections for consumers. And if that's not what's happening in the market, why don't they have the authority to say, we're going to try and figure out a way to make that happen in the market? Maybe eventually they'll decide they can't.
Yeah.
Or maybe they think they can.
So Your Honor, I think there are, I'll try to answer it short because I know I'm over time, but I think the answer to that question is if you look at the PSC's brief itself, pages 25 through 29, they cite 4 instances where the legislature responded to what they thought were problems with the ESCO market. They cite PSL 32D, 32.5D, PSL 30, and GBL 349. Each of those is introduced by the PSC in its brief as the legislature saw a problem with ESCOs, now that ESCOs were introduced, and the legislature acted. They enacted this statute and this statute and this statute. That speaks volumes about how the legislature can and does and intended to reserve the right to legislate with respect to ESCOs. That's not the same thing as saying, we're not getting involved, we're going to let the PSC do everything it wants to because this is part of the energy market. And I think this really reduces to that discrete question. This is a statutory interpretation issue, and if there is a regulation that's promulgated that's inconsistent with the statutory express language, the legislative history in that regard, the amendment in 2002, and the PSC's own admissions, I think it's proper for this court to reverse. And I don't want to test the court's patience, but if I can have just 15 seconds to address the mootness issue on this point,
You may.
to Judge Garcia's question. I think there is an order before this court. It was promulgated. It was the reset order. I know the reset order is not in effect, but there was a request below, very clear, it was a count, to declare that reset order, the regulations with respect to price on the ESCOs, as an invalid, ultra vires exercise of the PSC's authority. Couldn't have been clearer. The reason it wasn't raised below is because the first time we ever heard a mootness argument was in their opposition brief in this court. But to Your Honor's question, absolutely, that was an issue on which we're aggrieved because the court then remitted this for further proceedings, and not only is there a further proceeding going on, but it denied us the declaration, and then the low-income order was based on the very same order that's before your honors right now. So it's bootstrapping to say, well, and Mr. Bassenson told you what he's going to do. He's going to use the low-income order, which was based on the order below that is before this court right now. He's going to use that as a basis for saying the ESCOs don't get to raise this issue anymore. So it's clear, we're clearly aggrieved. We see the writing on the wall. We know what's going on over here. And that's why we properly preserve the right to challenge Judge Wax and the Third Department's decision with respect to the discrete issue that we raised in our pleading and that we were aggrieved on. The idea that the PSC has the authority to set ESCO rates is antithetical to the PSL and can't be squared with this legislative history.
Thank you, Mr. Cerulli.
Thank you, Your Honor, and thank you for the extra time. I apologize.
You're welcome. Mr. Birch?
Thank you, Your Honors, and I will be brief and try not to repeat anything, but thank you for allowing me a brief amount of rebuttal time. When you look at what the legislature did here, I think they set up a scheme that's organically grown where you have utilities being regulated. One thing I would correct from respondents' argument is the PSC certainly has the ability and the responsibility to make sure utility rates are just and reasonable. The Public Service Law doesn't say ESCO rates have to be just and reasonable. Obviously, we hope through competition that they are, and this is really about consumer choice. And the legislature, setting up a system.
Well, the purpose of this wasn't just to give them the choice to either get more expensive energy or less expensive energy because some nice young person came to their door and said, oh, why don't you buy your gas and electric from me? I mean, that wasn't the purpose. So to say that the Public Service Law doesn't say that ESCO rates have to be fair and just, it doesn't fit, to me, within the legislative purpose and scheme.
I'm not arguing that they shouldn't be fair and just. Obviously, we hope competition sets them in a fair and just way. I'm saying they don't have the power to set them. And to address your example of someone coming to the door.
The question is, do they have the power to set up the system to ensure that the rates being charged for utilities is fair and reasonable, are fair and reasonable.
And Your Honor, I think the legislature clearly has spoken on that, and they say, yes, you can regulate the rates of utilities. No, you can't regulate the rates of ESCOs. If they wanted to put that power into place, they have had times when this was hotly debated in the legislature, and they came out with a scheme that they did, and it's not this one. And to address your hypothetical of someone coming to the door, there are all kinds of consumer protection statutes in place, and rightly so. No one wants bad actors in this market, and the government has powers.
I'm not suggesting that they'd be bad actors. I'm just suggesting that the purpose of the system is to enhance the likelihood that consumers will receive the best prices for their utilities.
And again, I'd go back to the legislature spoke on this. There's competition. That's the broad policy of the state, except for limited circumstances like where there's monopolies acting. It's not for the Public Service Commission to make this decision. This is a very big policy choice. The legislature should make that decision, and they haven't. Thank you, Your Honors.
Thank you, counsel.